Most of us assume family court exists for one primary reason: to protect children and prioritize their best interests. But the system is actually built on an adversarial model. It is a structure designed for resolving corporate disputes or trying criminal cases, not for managing ongoing family relationships or child development. This setup turns the court into a pay-to-navigate environment. This stacking bar chart illustrates core cost drivers over a typical case. We start with hourly attorney fees, pile on guardian ad litem fees, and cap it with custody evaluators that can run up to $15,000 alone. Because these cases are financially open-ended, the expenses escalate alongside the intensity of the conflict. Ultimately, the quality of justice a family receives is capped by the depth of their wallet. Legal advocates call this the justice gap. Available legal aid is extremely limited, leaving middle-income families in a harsh bind. They qualify for zero financial assistance, but they do not have the liquid cash to sustain prolonged litigation. The system operates without spending limits. If one party decides to intensify the dispute, the total cost of the case scales upward without a ceiling. We see the result in this structural imbalance. On one side, the objective facts of a custody dispute. On the other, the financial endurance of the parties. When one side can afford to keep paying lawyers, endurance outlasts the facts. The court's structural design fails to equalize resources between parties, engineering an environment that consistently favors wealth over objective truth. Eventually, families hit a collapse point. When the less affluent parent's funds run dry, their attorney withdraws. They are forced to proceed pro se, navigating the remainder of the case entirely unrepresented. This timeline shows high-conflict economic warfare. A barrage of repeated emergency motions and discovery requests directly depletes the opposing parent's resources. Once that meter hits zero, the unrepresented parent hits a procedural wall, lacking the legal expertise to draft motions or comply with strict deadlines. A deliberate financial attrition strategy effectively silences a protective parent. The wealthier party wins the case not on merit, but by procedural default. The toll of navigating the court alone causes severe psychological and logistical strain. The unrepresented parent experiences rapid burnout and decision fatigue, which frequently cascades into housing or transportation instability. Here is where the system makes a crucial misinterpretation. Judges evaluate procedural execution and courtroom demeanor. They routinely mistake a parent's economic exhaustion and procedural errors for parental instability or a lack of cooperation. Because the exhausted parent no longer has the legal representation to formally submit evidence of abuse or risk, these critical danger factors go completely undetected by the court. The direct fallout lands squarely on the child. They lose access to a stabilizing parent, subjected instead to the toxic stress of chronic litigation. By penalizing poverty under the guise of procedural neutrality, the court effectively rubber stamps unsafe child placements. Legal inaccessibility is a system-induced condition that actively facilitates child abuse. Protecting children requires acknowledging the structural failure. An automatic right to counsel protocol ensures equal representation for both parties. Courts can implement fee shifting based on financial disparity. These nodes expand into a technology layer, routing complex legal formatting through a simplification filter for AI-assisted guided filing. These tools must be supported by trauma-informed training for judges, enabling them to properly identify financial coercion and separate stress-induced behavior from poor parenting. Because the pipeline of harm is structurally manufactured, it can only be dismantled through intentional systemic circuit breakers. Ultimately, the legal system needs to evolve how it defines the best interests of the child. Moving forward, courts must adopt a new required standard. As shown in this text layout, the traditional best interests of the child framework must append an access equity context. Judges must evaluate not only the evidence physically presented, but critically analyze what evidence could not be presented due to financial barriers. A child's safety and well-being must never be compromised simply because a protective parent's bank account ran dry.